crimes that don't really have a bad guy involved. Speeding, for instance. If you're not killing anyone, it's kind of hard to see why you would be punished harshly for it. You went faster than you were supposed to, you get a ticket, you pay the ticket. Well, if someone's stabbed, kind of see the problem. That behavior deserves harsher punishment. And we actually can see, we can visualize that behavior or see the results of that behavior. We also have an issue of privacy, freedom of thought, our ability to think evil thoughts without actually doing the thing that we're thinking of. The actus reus is that step of, again, going from attitudes, oh, I hate that person, to a deed, so I'm going to kill them, and then you kill them. We have a freedom to think evil thoughts. We don't have a freedom to execute those evil thoughts. Actus reus helps separate the line between thinking about the bad things and doing the bad things. Now, I mentioned about status. Let's go back there for a second. And I told you that actus reus does not include status. It's a voluntary behavior. It's voluntary conduct. It is not who the person is. And in fact, if legislatures go to that point where they're trying to criminalize a status or personal condition, and they try to criminalize it, then it will be unconstitutional. And the Supreme Court has held that. Now, most recently, in the Lawrence v. Texas case, that came out, I believe it was 2003, you had a very interesting decision. That was the sodomy case that came out of Texas. Two men were in the privacy of their own home having sex, and a neighbor called the police. There was a sodomy law in the book that said two men can't have sex. They were arrested and thrown in jail. So the people who were in jail sued, got all the way up to the Supreme Court, and the Supreme Court used the idea of privacy to prevent them from, or to call the criminal statute, or to call sodomy unconstitutional. And that case, in effect, made sodomy unconstitutional throughout the entire United States, even though it's still on the books in some places. But most recently, I think it was last year, a case came out of the Supreme Court that had to do with a gay association support organization in California. Without going into detail about the case, something very interesting was said by one of the justices. I think it was Justice Ginsburg. And that is, when it comes to homosexuality, the Supreme Court has yet to distinguish the behavior, homosexual behavior, sodomy, from being homosexual. And that, if you'd have read this case without listening to this class, you might have been, well, what's the reason? Why would that be important? Well, this is why it would be important. Because if being drawn to homosexual sexual relations is part of that person, then it becomes a status. It becomes a personal condition. And because of that personal condition, it could not be criminalized. And we've already seen that with sodomy being, laws being overturned. But now we're seeing that continue, where the status of homosexuality is the question, and whether laws can criminalize anything dealing with homosexuality becomes a question. And it just depends on whether or not eventually the Supreme Court will decide if homosexuality is a status. Now we're going to jump from actus reus as an actual deed, as an act, to kind of the opposite. And this to me is always the most fun part of actus reus, and that is omission. Failure to act. The reason why it's a humorous area, at least from my point of view, is how we Americans treat helping other people. Most states have what's called the American bystander rule. The American bystander rule. What that rule is boils down to this. You're walking down the street, you see someone getting mugged, and you just continue to walk on by. You walk down the street and see someone drowning in a lake. Oh, I have way too much things. I have too many things to do. I have grocery shopping to do. I have this and that. You see a spouse beating up another spouse. Oh, I don't want to get involved. This is just not something I want to do. It can go so far as seeing a kid in need, and we can just walk on by. That's the American bystander rule. We are not liable. We do not have, and the key word here, a legal duty. We do not have a legal duty to help people. Average Joe or average Jane does not have a duty to help those in need. We don't. That's just, the way things are. In a few states, there's Good Samaritan statutes that put that legal duty on a person. But questions always arise as far as, well, then what's the extent of that duty? When is it tripped? And how are you going to hold someone liable when the question will come, would that person ever have, if the person would have helped, would that have actually changed the situation? Now, talking about a legal duty, there are instances where a failure to act, like I said, there's the Good Samaritan rule, but legal duties can be created by statutes, by contract, and by special relationships. These three things can create legal duties. What do those legal duties create? They create a requirement to act, whereby a failure to act would satisfy actus reus. A failure to act would be voluntarily telling your body, don't go help the person. And that voluntary action is actus reus. Statutes, like I just said, the Good Samaritan law, could be, for instance, firefighters or someone who's licensed by the state, maybe a teacher, for instance. But this would be in the books. be in the laws of the state. It would tell